Hey everyone, it's Mattea with the Sierra Club Grand Canyon chapter, aka the Arizona chapter. I am our Grand Canyon program manager, and I'm based out of the unceded homelands of over 13 tribal nations in Flagstaff, Arizona. And I'm so excited to welcome you to Land Defenders, a podcast dedicated to the voices, stories, and wisdom rooted in the lands of the greater Grand Canyon region. Here, on land sacred to many indigenous peoples, each stone, river, mountain, and canyon wall holds stories of connection, reverence, and defense. In each episode, we challenge the forces threatening this living ecosystem and elevate the stories of those defending its future. From activists and elders to water protectors and land defenders, we're here to share the truth, confront injustice, and explore the deep-rooted connections that tie culture to conservation. Join us as we move beyond the rim and into the heart of the work to protect this region. Up next, you're about to listen to an episode in a series that we developed in partnership with 3 students from NAU focused on Snowbowl Ski Resort and the agencies that are supposed to hold them accountable. A few updates. The student semester has finished, so I will be taking over the podcast from here, and you will notice that audio is getting better throughout the series. This is a really grassroots project, and we're learning a lot along the way. Anywho, enough with that. I am really excited for y'all to listen to this episode with Dr. Jocks. He is quite an expert on the legal history related to and affecting the crisis on the peaks as it relates to Snowbowl. This episode will hopefully help you to understand how the heck Snowbowl was even allowed to exist on such a sensitive and sacred place, why certain legal actions have not worked, and how other legal cases that from the outside may seem unrelated have seriously affected the issues on the peaks. So without further ado, off to part 1 of the 2-part episode with Dr. Jocks. We are here today with Dr. Jocks, and I'm really excited about our conversation today, so thank you for joining us. Do you want to go ahead and introduce yourself to our listeners?
Yes, I'd be happy to. My name is Jocks. I'm a professor in Applied Indigenous Studies at Northern Arizona University. I introduced myself in the Mohawk language. I'm Mohawk. We call ourselves Kanien'kehá from the village of Goetz near Montreal, Canada. And I sit with the Bear Clan when I'm up there. I've been teaching at NAU for 11 years. I was actually, I began to be involved with the Peaks issue before that. My previous teaching assignment was at Fort Lewis College in Durango, Colorado. And I was, when I began teaching at Fort Lewis, there was a indigenous student club that asked me to be their advisor. So I happily agreed, and one of the things we got involved with was driving down to Flagstaff to participate in some of the events that were going on to express indigenous perspectives on the peak. So that's where I first learned about this issue, and I learned about it from my students, which is the best way to learn.
Mm-hmm. Absolutely.
And, it was a relatively small part of my work there in Durango, and then my next assignment here at NAU, shortly after I got here, I was asked by a group of Native people here in Flagstaff, an intertribal group, to come to a meeting where people were going to talk about the things that concern us and our ideas for making life better for Native people in Flagstaff. We are now a nonprofit. Our name is Indigenous Circle of Flagstaff. And in 2016-17, we held a series of 6 what we called Indigenous Community Forums. The city of Flagstaff helped sponsor these events. They wanted to hear from Indigenous people in Flagstaff, but we ran those events as Indigenous events. We told them, we want you to come and listen. We don't want to hear speeches. we're going to, it's like Vine Deloria's book, We Talk, You Listen. And they agreed to that. And one of the prominent issues that arose during those six community meetings was the issues around the peaks. So I've been involved around that ever since in a supportive role, trying to support our Indigenous communities and relatives here in Flagstaff, and then teaching about that to classes at NAU.
That's really interesting because I'm curious how the city of Flagstaff responded to that, because they're the ones that sell the water.
Oh my goodness.
To Snowbowl. So did that affect them in any way?
Here's how that got started. A city council member wanted the city to declare the second Monday in October Indigenous Peoples Day. Okay. And she went, Eva Putseva is her name, and she went around and began speaking with Indigenous people in Flagstaff about this until she ran into a group of 2 or 3 who said, actually, no. Let's wait. We don't want a purely empty symbolic event where Native people get a pat on the head once a year. The city of Flagstaff needs to do something to deserve to declare Indigenous Peoples Day. So what about instead we come up with a process to listen to our relatives here, for the city to listen to us and see what kind of change we can begin to develop before we talk about declaring Indigenous Peoples Day. So she agreed, and the proposal was dropped for that year, and that's how this whole process got started. It gets more complicated, and let's save that for a little bit further down the road in terms of the relationship with the city.
Okay. So you moved to Flagstaff from Durango. As you moved to Flagstaff, I'm sure your relationships to the peaks have changed, and the way that you've engaged with the issue has ramped up maybe more than when you were in Durango, or?
Yeah, absolutely, because I now live here.
Yeah.
I greet the mountain every morning when I wake up. And I began to hear, not just from students, but from, medicine people, from the legal teams that have been working on this. And I immediately realized I want to be able to teach about this, but I want to be able to teach accurately and from a way that respects what the people here are experiencing and their efforts. And as it turns out, my preparation as an academic, my PhD is in religious studies, but one of my specializations has always been on so-called sacred sites. I think that term is problematic, but that's the term we're stuck with. One of my PhD advisors had been an expert witness on the Ling case, which is the precedent that was cited by the Ninth Circuit Court of Appeals in the Snowbowl case. It's basically the precedent that some people would say would doomed that case from the beginning. He was an expert witness on the part of the tribes in that case. So I didn't realize it at the time, but I was learning about that case as a graduate student. I didn't realize I would be devoting a fair part of my professional life many years later on a case that followed after it.
Yeah.
Yeah.
Wow.
Yeah.
Okay. That's wild.
Yeah. Well,
it's all connected, though.
It seems like it is. It does seem that way to me.
Okay. So now, I guess let's go back into the history of the peaks and this issue and why it's even an issue in general. So the peaks and where Snowbowl is on quote-unquote public land.
Yeah.
What is public land? Why are the peaks public land? How did they become public land? When did that happen?
Right. I guess since so much of this ends up being phrased in terms of money, I kind of start out by saying that the United States government paid not a nickel for that land. What happened is that in 1868, when Arizona first became a territory, not a state, it's called the Arizona Organic Act is the legislation that made that possible in Washington, D.C. the territorial government, as they charted out the territory, deemed the peaks public domain. It was owned by nobody other than the public itself. National Forest Service didn't exist yet at that point. And what that in actual fact meant was that anybody who had a big enough saw could go up into the mountains and make a living cutting timber.
Wow.
There was almost no regulation. But anyway, that 1898 is when the San Francisco Mountain Forest Reserve was created by President Theodore Roosevelt, in part because there needed a forest. Even the foresters recognized that unless there was some kind of regulation here, the woods would all be gone. So, but that was, 30 years later. But anyway, getting back to the original question, there's the other important dimension of this is that the peaks have been, how do I put this here? Well, I have a phrase, members of at least 14 Native nations revere the peaks as the outer form of a sacred being, the home of sacred beings, or in some other sense, a place imbued with rare cosmic power and significance. That was true in 1868. It was true in 1368. But when the cartographers of the Arizona Territory began to map out, who owned what in that territory, they saw no native people living there, and so it became public domain. Because this is, I could say sacred place, but I'd rather say a sacred being or the home of sacred beings, nobody lived there. And there were no indigenous people saying, if I'm Hopi and I'm going up there to collect medicine, Navajos aren't saying, you can't go there, that's my sacred mountain. Native people, especially in a place like that, didn't exert that kind of property ownership, territoriality that we're so familiar with today. That makes it a little more intricate in terms of the legal status. This is traditional territory of all of those 14 tribes, but it's not traditional territory of any one of them, and never was. So we'll get more to the implications of that later. But that's it became part of the Coconino National Forest in 1908.
Okay.
That when the National Forest was created.
So now it's still Coconino National Forest, but it's also, and I don't know exactly when this happened, but the peaks have been given the designation of traditional cultural property. That's correct, right?
Yes.
What does that mean?
I mean, think about the implications of that term.
Yeah.
First of all, traditional cultural property. We usually think of property as things that can be bought or sold. I mean, to me, that's a prime example of the way legal language makes designations that are alien to the way indigenous people understand places. But nonetheless, that's the term that's there, at least under the National Historic Preservation Act, to protect so-called sacred places. They need to be designated, part of the process is that this place be designated a traditional cultural property. And that was done, I don't have the exact date, but that was a decision that the Forest Service made, I believe, in either before or during the environmental review that started in 2002. It's not older than that.
And has that designation protected the peaks in any way?
It may have exerted some minor, it may have been effective in minor ways, kind of around the edges in terms of recognizable cultural activities, like making sure that medicine people are still able to go up on the mountain to collect medicine plants. That kind of thing is easily recognized under the NHPA in the case of a traditional cultural property like this. But the breadth of that application is, I think what I'd say is the issue that Indigenous people have been faced with, the fact that they are continually being forced to narrow down the scope or the domain of what kind of activity is actually protected.
Yeah. Is there a relationship between the traditional cultural property designation and the American Indian Religious Freedom Act and how people are, through the eyes of the American government, allowed to have a relationship to this space?
The American Indian Religious Freedom Act has very broad language and is deficient in that there was never any enforcement mechanism attached to it. That deficiency was then compounded by the Ling decision in 1988, which we'll get to, which gave the Forest Service and any other federal agency standards of law in cases of sacred sites that made it very easy to favor federal agency actions at the expense of indigenous traditional practices. So a nice idea in principle, the American Indian Religious Freedom Act, but it has rarely been enforceable. It has rarely resulted in substantial protection.
Okay.
And I would say both in the case of officially designated traditional cultural properties as well as in other cases that didn't involve that status. It hasn't made much difference.
Yeah. Here I see the original permit for the Forest Service was 1979. Was there a ski resort in the 30s started?
There was. The Forest Service allowed skiers to come up, and I'm not sure exactly what kind of infrastructure was there. Gotcha. I don't think there was a lodge. I don't think there was a lift.
Okay.
It was just a place where people went up to ski.
Okay.
And there may have been a rudimentary cabin there or something, but it couldn't really at that point be called a commercial operation, and It was run by the Forest Service itself.
That makes sense.
It wasn't until 1979 that this Northland Recreation Company decided to create a commercial recreation facility there.
Okay. And when this commercial operation was established, how did tribal nations respond to this?
That's the thing that people might not be aware of. A lot of people in the Flagstaff area became aware of the treated wastewater issue and the lawsuit that resulted from that, and that master development plan in 2002. But this goes all the way back to 1979. Almost immediately, a lawsuit was filed. And the plaintiffs in this case were the Hopi tribe, the Navajo Medicine Men's Association, and I need to look into this. There were some local ranchers that joined that lawsuit, but that lawsuit was on religious freedom grounds, that the creation of this commercial ski area will burden the indigenous people's practice of religion under the Constitution. Now, that court case did not make it to the Supreme Court. The final decision was from the Second Circuit Court of Appeals in Washington, D.C. But that court in 1983, even, 5 years after American Indian Religious Freedom Act, ruled in favor of the ski operation, and essentially said that because medicine people can still go up to the peaks, and they define the peaks as the very top of the peaks, which there actually aren't any plants growing on the top. But that because the ski area existed at the bottom of the mountain, that traditional activities, specific traditional activities, were not prohibited, and that therefore there was no burden on the practice of religion. That ruling hasn't gotten as much, isn't as well known, but it points out to the way in which, and I've studied this in the U.S. and Canada, in which even when there is a substantial religious freedom burden, a claim of substantial burden to the practice of indigenous religion, quote unquote, that term's problematic too. But even in such cases, there are ways in which the nature of that traditional activity can be narrowed by the legal system to allow most commercial development to continue. So 1983, that decision is rendered, and the ski operation is in full swing. Of course, they are relying on natural snowfall. And in the 1980s, and for most of the time of the 80s, at least until the 90s, there seemed to be adequate natural snowfall for their own business plan. 1988 was when this decision was rendered in this Lyng case. It's L-Y-N-G. You can look it up. This was a religious freedom case that came out of Northern California. And as my dissertation, one of my dissertation committee members was actually a expert witness on the part of the three Native nations in Northern California, the Tolowa, the Yurok, and the Karuk, who brought that suit. The Forest Service was planning to build a logging road from one area to another area. It's a fairly long distance down at the bottom of this of a river valley, and these indigenous people, it went right underneath a place that was a ceremonial spiritual practice place up above. And their lawsuit stated that the rumble and dust of all these logging trucks going by would render their traditional practices impossible. It would disturb the peace that was required for these ceremonies to take place. So in this case, the end result was that this went all the way to the Supreme Court in the United States, and the decision was in favor of the Forest Service and its logging plan. Justice Scalia wrote that decision in which the scope under which anyone can claim that religious practices are burdened by government action on public land was severely limited. The ruling says that government action can only be prohibited if it specifically punishes an individual for practicing their faith, or if that government action coerces an individual into violating their faith. You can see that this is based on direct impacts of government action. The Supreme Court ruling in Lyng severely restricted what kinds of government action will be prohibited in the case of, because of its impact on religious practices, whether indigenous or anybody else's religious practices. The Lyng decision says that government action will always be permitted unless it punishes an individual for practicing their faith or coerces an individual into violating their faith. But this is even more important. The justices went on to say that they affirmed the Forest Service contention that on public lands, the interests of the United States as landowner should always take precedence over any claim that its action might burden anybody's practice of religion. So they didn't draw this specific analogy, but it's as if I put up a statue of the Buddha on the front lawn of my privately owned home, and my neighbor next door says that violates my practice of religion, it's my private property. I can put up a statue of whoever I want. They're likening the U.S. government to a private landowner. And so the Forest Service, as the representative of the United States in this case, has decided that it's a priority to create this logging road that supersedes anybody else's problem with that in terms of their practice of religion. It really severely undercuts what's actionable in a case like this.
I see.
Here's the other thing. About halfway through that Supreme Court deliberation, this only came out later, internally the Forest Service decided they were not going to build the road. It was not economically feasible. They weren't going to be able to make enough. That is, the logging industry was not going to be able to make enough to make it worthwhile. Mm-hmm. The Forest Service wouldn't get enough logging fees, so they canceled the project. But they didn't cancel the Supreme Court case. Why? Because of the precedent.
Yeah.
And the precedent was there in 2006 when the Ninth Circuit Court of Appeal ruled on the Snowbowl case. So that's why it's relevant to this. Wow. I'm going to tell you a little story. I'll try to keep it short. But this is something my dissertation committee member related. He was being given an endowed chair, and it was a celebratory event. And apparently there was a tradition where one of the other faculty members would roast the person being honored and say nasty things about them.
Yeah.
So another faculty member started saying, Dr. Michelson, you got involved in this religious freedom stuff just because it was fashionable and trendy. And he got up. He was a tall, very thin man. He was of Norwegian ancestry. We called him the man of wood because he was the kind of person that could tell a joke and you never knew it was a joke. You go, is that a joke? I don't know. He was like that. He was really good at that. But anyway, he got up and he said, when I was working on that case, I decided I wanted to be there, to go up there to that Dr. Rock myself. I asked permission, was given permission to go up there, and I hiked up there to the top of that mountain. I spent most of the day up there. And about mid-afternoon, I started hearing voices. I heard people singing and I heard drums. I walked all around that mountain. I found no living human being. Then he sat down.
Yeah.
You can imagine, as a graduate student, an Indigenous graduate student, what it meant to me to have this person make that recognition in public, especially somebody who was known as the most unsentimental person you could imagine.
Yeah.
But to me, I remember that always because it reminds me that of the gulf between the legal system and how it approaches these issues and these conflicts, and the kind of experiences that inform how Indigenous people and others relate to these places. Here's a related facet of this, is that it came out in the Ninth Circuit deliberations regarding Snowbowl. There were non-Indigenous people who wished to and who did testify in the EIS process for the Master Development Plan about their spiritual relationship with this mountain. Their testimony was deemed almost irrelevant to the case at hand because this was a case about Indigenous religious practices, not about anybody else's. In other words, if you're not Indigenous, you don't count. I forgot to mention, that my dissertation committee member was not an Indigenous man. Okay, enough of that. But anyway, that Ling case became the solid precedent that enabled the Ninth Circuit Court, full Ninth Circuit Court, to rule against the 13 tribes in the Snowbowl case. That the federal government's interests as landowner superseded anyone's religious connection to this place, and that the existence of the ski area did not actually specifically punish any individual for practicing their quote-unquote religion. Yeah. Well, let me continue on, because there's a second really important Supreme Court decision that also features here, which was Employment Division versus Smith. And this was not about a sacred site, but this was about peyote. Alfred Smith was a member of the Native American Church, which uses peyote as a sacrament, which regards peyote as a sacred sacrament. This was in the state of Oregon, and when he returned from a weekend at which he had been at a Native American church ceremony, he was asked whether he had participated in this event. The possession of peyote at that point was illegal under U.S. and Oregon law. And he said, I did not engage in the use of the scheduled drug peyote, but I did take part in the sacrament of the Native American Church. He was summarily fired from his job, get this, as an alcohol rehabilitation counselor.
Wow.
There's considerable evidence of how effective Native American church participation is in Native people overcoming alcohol addiction. It's something that's well known. So ironically, because of his participation in NAC services, he was fired. So he brought a lawsuit against the unemployment, because he was denied unemployment by the state of Oregon, because it was regarded as a criminal offense.
Wow.
So this too went all the way to the Supreme Court, and here's where another damaging precedent was set, maybe even bigger. Now, this employment decision, Employment Division versus Smith's decision, was written by Scalia. I erroneously a minute ago said that the Ling decision was written by Scalia. I got them mixed up, but no, that one was written by Justice O'Connor. But in the Smith decision written by Scalia, he decided that the compelling state interest test, which I'll tell you about in a minute, is a luxury we can no longer afford. The compelling state interest test goes back to a case called Sherbet back in the early 60s, and it says that an action by the United States government that threatens or burdens somebody's practice of religion can only be acceptable or justified on the basis of a compelling state interest. There are two pieces to this. The action must meet a compelling state interest, and there must be no less burdensome way for the government to meet that interest. So, for example, if I decide that my religion says I need to, explode a bomb in the middle of I-17, the United States government can rightly say we have a compelling state interest in prohibiting that. In other words, freedom of religion cannot ever be completely absolute, because we have no control over what religion might dictate. But public safety and public health, for instance, are compelling state interests. And so if my practice of religion is going to endanger public health or public safety, that could be cause for that expression of religion to be prohibited by the government. That had been the standard since the early 60s. And it came up in cases like the Amish community wanting to be exempt from state requirements in Pennsylvania to force students to go continue through, age 16, and they wanted a lower age limit. And the decision was, we see no compelling government interest in forcing students to go to school until age 16. If it was changed in this case for Amish people to go to school only till 14 or whatever it was, I forget, that's okay. And so that's how that case went. Because of that, then Justice Scalia comes along in this Smith decision and says that we do not want judges to have to go through and decide this compelling state interest test. Does the interest in protecting people from prohibited drugs overweigh the value of the use of peyote in a traditional ceremony? We don't want judges to even have to make that decision. If the state of Oregon says we prohibit it, that's good enough for us. That's basically what Scalia's argument, what his finding was, and he expressed the majority opinion in that case. So all of the evidence that the defendants, Alfred Smith and his crew, his team had put together to show that this is in fact not a harmful drug. It has testified and documented benefits. None of that was ever heard by the court. Scalia basically cut that all off at the pass and said, we don't even need to hear that. We're just going to take the state of Oregon's word for it. Now, because of that, it was recognized that this could potentially weaken the protection of religious freedom for everybody. It was a taking out a foundation stone of the protection of religious freedom. And so after a lot of lobbying, in which I participated in a minor way, in 1993, the U.S. Congress and President Clinton signed a Religious Freedom Restoration Act, which restores that compelling state interest test that Scalia had uprooted. So that Religious Freedom Restoration Act was cited by the team in the Snowbowl case as a reason why the court needs to look more closely at the balancing act of the needs of the federal government. Yeah. The federal government really needs to have a ski area on this mountain. Is that a compelling federal interest? Yeah. And the practice of religion. Unfortunately, that argument didn't win the case, but it sounds like a pretty darn good argument to me. Yeah. Whew. All right. Well, this brings us up to the case that people are most familiar with. In 2002, Arizona Snowbowl Resort submits a master development plan, which is supposed to be like a 20-year development plan. But headlining this plan, which included more ski lifts, more lodges, but also most fundamentally the use of treated wastewater to make snow. This was unprecedented. We've looked around and we cannot find another ski area anywhere that uses treated wastewater to make snow, especially to the extent that Arizona Snowbowl has done.
Yeah, just a note in here. Yeah. Arizona Snowbowl is the only resort in the entire world that uses 100% reclaimed sewage water to make their snow. And if the upcoming years are anything like this year, just about all their snow is artificial snow.
Right.
Yeah. Okay, just a caveat on this. At the time that Snowbowl began to use reclaimed wastewater to make their artificial snow, they were the only resort in the world to be using 100% reclaimed wastewater to do so. However, right now, I'm having a hard time fact-checking if that still holds true today. It's unsure if other resorts also use 100% reclaimed wastewater for their artificial snow. So just throwing that out there.
And in terms of transparency, there's some question about whether 100% use of treated wastewater for snowmaking is even permitted under the permit that the Forest Service issues with Snowbowl. And we were told, that is, the public was told during the publicity around this court case, the big court case that was decided in 2008, that Snowbowl was telling everyone, we're only going to use it when necessary. It's not going to be 100%. But it's been very clear that even between then and now, natural snowfall is just not reliable for a significant duration of their ski season. And that's, especially when you look forward to the new master development proposal, they're wanting to expand and continue to grow, even at the same time where snow is becoming, well, look up there today. There's no snow on the mountain, and it's January 9th.
Yeah.
So that's a huge issue. Yes, as you point out, this is unprecedented, what was being proposed even in that 2002 proposal. So a master development plan under Forest Service regulations triggers a full environmental impact statement. And that's a large undertaking. I'm not as familiar as other people with the ins and outs of exactly, I have read through this statement. It's like 300 pages long. There's a public comment period, and this is where, well, what happens is the Forest Service lists, Forest Service or any other agency will list usually 3 alternatives: a full development approval alternative, a partial or compromise development proposal, and a no development proposal. And then there are public comments where people, talk about or give their testimony as to which of those alternatives they prefer. Anybody who was around Flagstaff knows that that these were well publicized. The public testimony was divided between almost universal Indigenous and ally testimony that we want none of this, testimony even trying to explain the spiritual significance of the mountain, and business interests saying that this is vital to Flagstaff's economy and we can't do without it. Anybody who wants to learn more about that phase should look at the Snowbowl Effect, the film that Cleve and Ali made, which has a lot of footage of what that testimony looked like, including an event where I think, was it City Flagstaff or Snowbowl proponents had a glass of the treated wastewater, and this is the most famous scene in that film, and was saying, this is perfectly safe drinking water. You can drink this. And somebody in the audience said, let's see you drink it. And the guy says, I'm not going to drink it.
I remember that scene. Yeah, he was trying to show that he had 2 glasses next to each other. One was like tap water, and one was the reclaimed sewage water. And he's like, look, they look the exact same. And and then she was like, well, drink it. And he's like,
He hemmed and hawed. In the end, he said, no, I'm not going to drink it. And the crowd by that time insisted, we want to see you drink it.
Even though he was trying to claim, he was literally trying to tell people, look, it's just as clean, it's totally drinkable and safe. Yeah. And then he refused to.
Yeah. Well, most folks in town are aware of the final decision on this, which used the Ling decision especially to overrule the religious freedom claim. And let's not forget that this was not only a religious freedom case as the 1983 case was. This also involved public safety and endangered species claims about the treated wastewater, that this would be a threat to endangered plant and perhaps animal species, and that it was a public health hazard. And essentially, the environmental impact statement and the Forest Service, in their record of decision, which of course chose the full development alternative, stated that they just couldn't make they could not prevent the development because of those concerns, because there was not adequate data about any of them. So rather than say, without adequate data, we need to wait and get adequate data, their response was, the data's not there, so we don't see a threat. We don't see a danger. And interestingly, the original Ninth Court, originally this went before a panel of the Ninth Circuit Court of Appeals of 3 judges. People may not realize those judges voted in favor of the tribe. Their decision was in favor of the tribe. They said that the religious freedom issues are palpable and real, and that the public health issues and the environment or endangered species issues are not adequately addressed in the EIS.
That was in 2007?
That was in 2007.
Okay.
Immediately, Snowbowl filed to have this heard by the entire Ninth Circuit of 9 judges who reversed the panel's decision. So I think that's significant. There was enough validity in the case that was presented for the original appeals court to actually say, you're correct. Mm-hmm. But then the nine judges ruled the other way around. So there's a phrase here that I always have to tell people because it reveals how the constitutional protection on religious freedom, how easy it is for legal experts to reduce it, to reduce that protection. In the final ruling, the judges wrote that the use of treated wastewater to make snow on this mountain does not impose a burden on indigenous religious belief or practice, but only on their, quote, subjective emotional religious experience, unquote. To me, as somebody who actually has a PhD in religious studies, it's very, very clear that they've divided up what, okay, first of all, the whole category of religion is a problem to begin with. And I could go on and on about that, but since we're stuck with that because the Constitution uses it, the judges in this case made a slice there and took out what they're calling subjective emotional religious experience and said that's not part of it. It's a way of trivializing. Honestly, this is what makes me so upset. It trivializes all the testimony that Native people had brought about their relationship, their understanding with sacred beings who have been there since the beginning of time and even before that. That's just your subjective religious experience. Mm-hmm. That makes the whole concept of religious freedom protection meaningless, completely meaningless. Mm-hmm. And there's no precedent for that. They made that up. Mm-hmm. As a way to say your religion doesn't count, or at least your expressions of why this is important to you don't count. You're just being emotional. You just got your feelings hurt. Mm-hmm. The possibility of a ruling like that was evident from the beginning, and it was even evident in some of the public comments. It's so easy for people who think of religion in terms of Catholic versus Protestant versus Jew versus Muslim, and those were the people, that's how the framers of the Constitution were thinking when they wrote that amendment. That is, most of the religious freedom cases in U.S. history have involved difference of religious theology or difference of ceremonial practices in the context of a church. Sometimes they involve things like church property and property rights, tax exemption, things like that. Mm-hmm. But the concept of a for lack of a better term, religion or a relationship with places that involves sacred beings just doesn't translate for most judges. A Canadian legal scholar that's wrote about this, I can't think of his name right now, wrote that judges need to be educated. Somehow we need to find ways so that judges can understand religion isn't just about Protestants and Catholics. But they're not.
Yeah.
And that makes it easy for them to make a ruling like this, especially when, this is the other big component, when money is talking. When money is talking and the United States ski lobbying organizations are saying we can't have ski areas having to adhere to or bend to or reduce their business operations because some Native people don't like it. So when you say it that way, because some Native people don't like it, it's just their subjective emotional religious experience.
Sorry about the heartbreak on this one. It was a little bit tough to figure out how to split the conversation in half, but I promise you where I start again in the second half is exactly how the conversation flowed. So it was a very natural spot to take a break. Again, this is just the first half of a 2-part episode with Dr. Chris Jocks. Please take some time to listen to the second half of the episode, also available on our channel, and share this with your friends across the region, especially locally here in Northern Arizona and in Phoenix. And recognize that even if you're not local, this issue still affects you and is a piece of a much larger puzzle of the colonization, desecration, extraction, profitization of sacred lands across the so-called US, which I'm sure you're picking up on, especially after this episode, if you haven't already. And it especially affects you if you live close to the peaks, where the best way I can think of trying to describe it is the peaks are like this keystone landscape and in this region, and we'll go into this in future episodes, but they're being destroyed by this operation, and they will continue to pollute our waters, pollute the plant and animal medicine up there, and make the land less resistant to fire, which is really scary to me and feels like this continual slap in the face when we, as we regionally are shifting towards a warmer and drier climate here, seeing companies like Snowbowl continue to put profit over the safety of our community, over the safety of future generations, over the continual, consistent, and clear asks by tribal nations to not do what they are doing, is really sad. It's really scary. And I'm just going to leave this episode with Winona LaDuke quote. She says, "Someone needs to explain to me why wanting clean drinking water makes me an activist, and why proposing to destroy water with chemical warfare doesn't make a corporation a terrorist." So, I think it's a good quote to reflect on in relation to these episodes as we dive into the legal aspects of this issue and really question who and what our legal system considers the problem and who and what they ultimately uphold. And before I jump off, I also want to share a huge thank you and shout out to our partners at Beyond the Pines, a local wellness collective here in Flagstaff, created to promote connection and service of human and planetary thriving. They have been instrumental in supporting us in starting and continually producing the podcast. And you can find their podcast at Beyond FLG and on their website and Instagram, also at Beyond FLG. All right, and with that, I hope to see you at part 2 of our episode with Dr. Chris Jocks. If it's not available on our channel right now, it will be very soon. All right, see you there.